Section 7. Hindu Marriage Act 1955. 7 Ceremonies for a Hindu Marriage. 7. 1. A Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto. 2. Where such rites and ceremonies include the saptapadi, that is, the taking of 7 steps by the bridegroom and the bride jointly before the sacred fire, the marriage becomes complete and binding when the 7th step is taken. State Amendments Section 7A Pondicherry. After Section 7, insert the following section, namely: A. By each party to the marriage declaring in any language understood by the parties that each takes the other to be his wife or, as the case may be, her husband, or B. By each party to the marriage garlanding the other or putting a ring upon any finger of the other, or C. By the tying of the thali. 7. 2. A. Notwithstanding anything contained in Section 7, but subject to the other provisions of this Act, all marriages to which the section applies solemnized after the commencement of the Hindu Marriage, Madras Amendment, Act, 1967, shall be good and valid in law. B. Notwithstanding anything contained in Section 7 or in any text, rule or interpretation of Hindu law or any custom or usage as part of that law in force immediately before the commencement of the Hindu Marriage, Madras Amendment, Act, 1967, or in any other law in force immediately before such commencement or in any judgment, decree or order of any court, but subject to subsection 3, all marriages to which this section applies solemnized at any time, before such commencement shall be deemed to have been, with effect on and from the date of the solemnization of each such marriage, respectively, good and valid in law. 7. 3. Nothing contained in this section shall be deemed to A. Render valid any marriage referred to in clause B of subsection 2, if before the commencement of the Hindu Marriage, Madras Amendment, Act, 1967. I. Such marriage has been dissolved under any custom or law, or 2. The woman who was a party to such marriage has, whether during or after the life of the other party thereto, lawfully married another, or B. Render invalid a marriage between any two Hindus solemnized at any time before such commencement, if such marriage was valid at that time, or C. Render valid a marriage between any two Hindus solemnized at any time before such commencement, if such marriage was invalid at that time on any ground other than that it was not solemnized in accordance with the customary rites and ceremonies of either party thereto. Provided that nothing contained in this subsection shall render any person liable to any punishment whatsoever by reason of anything done or omitted to be done by him before such commencement. 7. 4. Any child of the parties to a marriage referred to in clause B of subsection 2, born of such marriage shall be deemed to be their legitimate child, provided that in a case falling under subclause I or subclause 2 of clause A of subsection 3, such child was begotten before the date of the dissolution of the marriage or, as the case may be, before the date of the second of the marriages referred to in the said subclause 2. Ved Tamil Nadu Act 21 of 1967, Sector 2, WEF January 20, 1968. Institution or the formation of a Hindu marriage can be found under Hindu Marriage Act, 1955, which clearly lays down certain conditions prerequisite for the formation of a marriage, or the conditions necessary for a marriage to become valid in the eyes of law. Section 7 of Hindu Marriage Act, 1955 provides certain ceremonies to be performed under the heading Ceremonies for a Hindu Marriage. It is important to know the conditions under which Hindu marriage can be termed as a valid marriage, or legal authentication. So far as Old Hindu law is concerned, Manusmriti, or the laws of Manu, describes 8 kinds of marriage. Brahmana, Brahma, where the father of the bride invites a man learned in the Vedas and is of good conduct, and gives his daughter in marriage to him after decking her with jewels and costly garments. God's Daiva, where the daughter is groomed with ornaments and given to a priest, who duly officiates at a ritual of sacrifice during the course of the performance of this rite. Rishis, Arsha, when the father gives away his daughter after receiving a cow and a bull from the bridegroom. Prajapati, Prajapasya, where the father gives away his daughter after blessing the couple with the text, "May both of you perform your duties together." Ajuras, when the bridegroom receives the bride after bestowing wealth to her kinsman and to the bride herself according to his own will. Gandharv, the voluntary union of a maiden and her lover, which arises from desire and sexual intercourse for its purpose. Rakshasa, when the bride is forcibly taken from her home and from her family. Paisacha, when a man forces himself on a girl who is sleeping or intoxicated or is mentally unbalanced or handicapped. But the present law in the form of Section 7 of the Hindu Marriage Act provides that a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party, and specifies that where such rites and ceremonies include the saptapadi, that is, the taking of 7 steps by the bridegroom and the bride jointly before the sacred fire, the marriage becomes complete and binding when the 7th step is taken. So the marriage may be solemnized as per the customs of the community. For instance, a community may provide for a mere exchange of garlands, while another may require a more elaborate yajna ritual. The Act takes into account these differences. The Act is very clear on one point, however. As per Section 5, any 2 Hindus can perform a valid marriage. So, it is clear that the enactment lays down no bar on intercaste marriage. As long as the 2 parties are Hindus, they can marry each other. If a Hindu resident in India wants to marry someone who is not of the same religion, they will have to get married under the Special Marriage Act, 1954. Marriage will not be valid if conducted under the HM Act. The most important condition prerequisite for a Hindu marriage is Saptapadi, i.e. 7 steps taken by the bridegroom along with his bride jointly before the sacred fire, and it is a mandate because it is this ceremony which, according to Hindus, marriage is scary. As and when the 7th step or round is completed, marriage becomes binding on both the parties, and this is the point which ties them in the relation of husband and wife. Another important ceremony, though not mandatory, for the completion of a Hindu marriage is Kanyadan. This practice has been followed by Hindus for a long period of time, and this ceremony was mandatory for the marriages organized in accordance with Brahma form of marriage. After the enactment of Hindu Marriage Act, this ceremony is no longer obligatory for a valid Hindu marriage in the eyes of law, and this view was held by Andhra Pradesh High Court in the case of Ramlal Agarwal v. Shantadevi Air 1999 AP 251. In earlier times, it was a common practice among the Hindus to get their daughters married at an early age, and a father had to give his daughter to the bridegroom. In fact, he had a right to do so. But, this right is no longer available as marriage of girls below the age of 18 is not legal in the eyes of law, though its validity is altogether a different issue. One important point which has to be kept in the mind is that if it has been alleged by either of the parties that certain ceremonies have been performed during the marriage, but later it is found that those ceremonies have not been conducted, then such a marriage would not be valid in the eyes of law. This was the view opined by the Supreme Court in the case of Shanti Dev Barma v. Kanchan Prawa Air 1991 SC 816. Another important thing which is of utmost importance is that a marriage can be organized in any of the customs approved by a particular section of society, because it would be very difficult to enact a particular law which can be applied uniformly on all sections of the society. Even among Hindus, there are a large number of subdivisions, and the practices followed by these sections are not the same, and very often they vary from each other. In other words, it is not possible to have an impeccable law for all sects of Hindu which can be followed by all of them. Here comes the role of custom of a particular section, group, sect etc. of Hindu which has been followed by them. Under the Indian legal system, Sikhs, Jain, Buddhists come under the category of Hindu, and it is not necessary that the same customs would be followed by all of them. But, Marriages conducted under these religious would be governed by Hindu Marriage Act, 1955. Let's take a quick look. Coming to the facts of this case, the Council of Appellant Husband argued before the Bombay High Court that Section 7 of the Hindu Marriage Act 1955 necessitates the Saptapadi ceremony, taking 7 feras around the sacred fire. It was also argued as follows. 1. Instead of taking 7 steps around the sacred fire, they took steps around a bundle of agarbatti sticks which were burnt. 2. The priest who solemnized their marriage is not a regular pujari of the Hanuman temple and did not visit the temple on a regular basis. Given the nature of the dispute, the evidence of the priest was examined very carefully by the courts, and here's a summary of his side of the story. 1. The bride and bridegroom, along with their family members, came to solemnize the marriage as per Hindu customs in the temple. 2. At the time, the bridegroom did not oppose the marriage ceremony. It is the bridegroom's mother who had brought sindoor to the temple for the ceremony. The bridegroom also put the sindoor on the bride after the ceremony. There was no sign of the bridegroom being compelled or forced. He did not oppose anything. 3. The priest had not known about the Saptapadi ceremony and therefore, he had not conducted it. However, the bride and bridegroom had taken 7 steps around a bundle of agarbattis, incense sticks, that were burnt. The Bombay High Court observed as follows in this case: if in fact, the marriage was solemnized by force, there would be no question of the 2 persons cohabiting with each other for so long, and that too by having a physical relationship. Some observations put forward by the petitioner include: what is a sacred fire has not been defined in the Act. Sindoor was put by the appellant, bridegroom, on the respondent, bride, and he garlanded her. The Bombay High Court dismissed the husband's appeal, seeking his nullity of this marriage that took place on February 14, 2009. In S. Nagalingam v. Shivagami, 2001 7 SCC 487, the question came up whether Saptapadi is an essential ritual for the validity of Hindu marriage in the case of a second marriage. While holding that a second marriage as indicated in this case is not valid as per Hindu law, the Supreme Court also held as follows. 1. A Hindu marriage may be solemnized in accordance with the customary rites of either party, bridegroom or bride. 2. Even a simple ceremony of exchanging garlands, tying a thali, Mangalsutra, or putting a ring upon the finger is sufficient to constitute a valid Hindu marriage. Given that the dispute is around what constitutes a Hindu marriage, here are some interesting facts to know. Marriage as a sacrament under Hindu law. According to Hindu law, marriage is a sacrament, not a contract. So, what are the characteristics of sacramental marriage as per Hindu law? It is as follows. 1. It is a permanent and indissoluble union. 2. It is an eternal union. 3. It is a holy union. Note that these 3 characteristics have been done away with because 1. Divorce is now legally recognized as per Hindu law. 2. This was done away with in 1856 when widow remarriage was given statutory recognition. 3. This may still remain in the context of the ceremonies that are a part of the Hindu marriage ceremony. Although the ceremonial aspect is the least important characteristic of a sacramental marriage, the Saptapadi or taking the Sothfaras is considered the most sacred of the nuptial ties, rendering the marriage complete and irrevocable in law. Now let's come to a tricky question. What if a Hindu couple gets married to each other without taking the Sothfaras? Is their marriage null and void? The question regarding essential ceremonies of a Hindu marriage still remains varied and unanswered in concrete terms because the judicial pronouncements till date do not clearly lay down the essential, must-do ceremonies for a Hindu marriage. Another important point to note is that as per the Hindu Marriage Act, if a marriage has been solemnized by customary rites and ceremonies of at least one party, either the bridegroom or the bride, the marriage will be considered valid. Conclusion. The slides explains about the Hindu Marriage Act 1955, important points of SEC 7. Section 7 Ceremonies for Hindu marriage.